I mentioned earlier that the automatic stay is described in Section 362, in particular 362A. 362B has a list of things that are not stayed when the bankruptcy is filed. So it's a fairly long list. I'll cover a couple of them here because I think we'd be here all day if we went through the entire list. The first is if there is a criminal action or proceeding against the debtor. So if you're in trouble with the law and there's a criminal action against you, you can file for bankruptcy and it'll stop creditors, but it is not going to stop the district attorney from prosecuting you for whatever crime you may or may not have committed. Another thing has to do with what's going on in a dissolution of marriage. For example, there may be proceeding to determine paternity. Well, that's not stayed. Or there may be a proceeding to determine what your domestic support obligations are, or to determine child custody or visitation, or the dissolution of the marriage itself, or regarding domestic violence. Those proceedings are not stayed. However, what is stayed is any division of property. So when a couple gets married, now this is where California law does kick in because not every state is like this. We have what's called a community property regime. What does that mean? It means when a couple gets married, all of their possessions get divided into three categories: the husband's separate property, the wife's separate property, and the community property. What goes into these categories? Anything a spouse comes into the marriage with, and anything a spouse inherits is that spouse's separate property. Everything else is community property. Now, on the day you get married, there is no community property. Why is that? Well, everything you have, you're coming into the marriage with. But then as the years roll by, you buy stuff. Well, how'd you pay for it? With wages, community property. Wait a minute, those were my wages. Doesn't matter. The wages you didn't come into the marriage with, you didn't inherit, so they're community property, and anything you buy with wages is community property. Why do we care? Well, there are two contexts in which this becomes important. The first is in a dissolution of marriage. The second is in dealing with third-party creditors. So in a dissolution of marriage, one of the steps is the division of the assets. How is that done? Husband gets his separate property, wife gets her separate property, and the community property is divided 50-50 as much as possible. There's usually some horse trading on this. So, for example, okay, you get the house, but then you pay me equalization payments for a certain amount of time to cover the equity that was in the house at the time that you got it. So in that mindset, it's a 50-50 proposition. So if the marriage is going through a dissolution, and you're at that stage of, well, I'd like to divide the assets, the automatic stay stops that. Other aspects of the dissolution can proceed apace, but not that. You might wonder what happens in dealing with third-party creditors, this whole community property issue. Well, let's say one of the spouses owes money to ABC Bank, and that spouse signed a contract, and now that spouse isn't paying. The other spouse knows nothing about it, never signed the contract, never had anything to do with it. What can ABC Bank do? Well, I think we can all agree that ABC Bank can go after the separate property of the spouse that signed the contract, because after all, that spouse is going to take the property in a dissolution that belongs to that spouse. I think we should also agree that in the interest of fairness, ABC Bank cannot go after the separate property of the other spouse, because that spouse had nothing to do with the contract, had nothing to do with the debt. What about the community property? What can ABC Bank do? It can go after them. 50%? No, 100%. And you might wonder, why the difference? I thought it was a 50-50 proposition. Well, the law, in essence, says it's an undue burden on the creditor to try to figure out which half of the community property belongs to the debtor spouse and which half belongs to the non-debtor spouse. So that's resolved by saying that the creditor can go after all of the community property. So as a result, if one spouse files a bankruptcy without the other filing, that's not required that you file jointly. then that's filing spouse has to list that filing spouse as separate property and all of the community property, because all of the community property is liable for that spouse's debts. And that spouse has to list all of the non-filing spouse's debts as well, because that community property is liable for that. But in essence, what we're talking about here is that the division of assets in a dissolution is stayed while the automatic stay, that portion is stayed while the automatic stay is in place, but other aspects of the dissolution are not. Also, collecting domestic support, that is not stayed. So if you've got an obligation to pay child support or alimony, you file bankruptcy, well, that collection can still continue as long as it's not coming out of property of the bankruptcy estate. So if it's your wages, for example, that can continue to be collected by the person who is entitled to that domestic support. So there's also the issue of the withholding or suspension of a driver's license. That can also continue even though the automatic stay is in place. There are others, and if you're really interested, go take a look at the Section 362B of the Bankruptcy Code. It's got a lot of them. But for most people, those are non-issues. Really, the issue is it's going to stop all creditor activity against you and give you some breathing room so that you can sort of recover and get rid of debts or deal with them efficiently.